Thank you, Taylor. As Taylor mentioned, I am an associate here at Tully Rinckey. Before I joined Tully Rinckey, I spent several years practicing child welfare law in New York City, as well as in Buffalo and Erie County. And so what I'm hoping to do today is help everyone get a general overview of what a child welfare case looks like, both from the very beginning when the report comes in, all the way through the investigation, any court proceedings, and ultimately to how the cases will end. There's a lot to cover, and so I'll be moving somewhat quickly because this is obviously a topic where I could do an entire presentation on any one of my slides. So if there are any questions, please feel free to send those to Taylor and I'll be happy to discuss those. On the next slide, before I jump into everything, just a few acronyms that I'll be using or you might see or hear during the course of a child welfare investigation. First of all, ACS, the Administration for Children's Services, is a city agency based in New York City. They, in New York City, are the agency that is in charge of child welfare cases. Pretty much anywhere outside of New York City that's still in the state of New York, it'll be run at a county level through the local Department of Social Services. So I'll be referring to that as the agency or the department or just as ACS or DSS. Similarly, there are a number of different types of caseworkers within the various agencies, both through the actual investigating child welfare agency, ACS or DSS, and also through the foster agencies. Every jurisdiction has slightly different terminology. For instance, in New York City, they have a PD CPS worker, which is the person who does the initial investigation, and then the FSU CPS worker, who is the person who monitors the family down the road as they're participating in services. That's a New York City terminology. They call it something different in Erie County, and I'm sure in every other county they have their own specific language, but these are all essentially the caseworkers who are going to be working with the family. When the case goes to court, there'll be an AFC. This stands for Attorney for the Child or the Attorney for the Children. They're pretty much always assigned in a child welfare case. They'll often also be assigned in other family court matters, custody and visitation. Usually, if there's a child participating or really relevant to a family court matter, there will often be an AFC assigned. In child welfare cases, there's no plaintiff and defendant like you've heard of in a criminal case. Instead, it's the petitioner and the respondent. The petitioner is always going to be the person or the agency that brings the case. 99% of the time, that's going to be ACS or DSS. Other people can technically do it, but they very rarely do. So the petitioner is almost always the governmental agency bringing the case. The parent or person who is being charged with neglect or abuse will be referred to as the respondent. This is similar to being the defendant in a criminal case. Obviously, we're talking about children, so there can be other people involved in the family who are directly relevant to the child's life, who play a day-to-day role in the child's life, but aren't actually being charged. Usually, this will be if only one parent is being charged, then this is what the other parent is classified as, or if there's someone who has custody but isn't being charged, something like that. They're just generally referred to as non-respondents, usually with some kind of additional clarification. Non-respondent father, non-respondent mother, non-respondent guardian, something like that. Finally, I've got a whole list of acronyms down at the bottom of the slide there that you can see. I'll be talking about the individual types of court proceedings towards the later on in this presentation, but those are all just shorthand kind of references to the types of court proceedings. Now, moving beyond that, before we talk about court, I want to talk about the investigation. And so, Taylor, we can go forward a couple slides. First, I'm going to talk about where reports come from. Anybody can call in a child welfare report. There's a 1-800 number for the entire state of New York. In New York City, you can also just call 311 and say that you want to make a child welfare report, but anybody is capable of calling these in, and they all go to the same place, and they're treated with the same level of importance. They go to what's called the State Central Register, or SCR, which, like I said, receives all of the child welfare complaints. They conduct a brief kind of interview with the source of the complaint and get information about if it's really valid. And then they're not making a judgment about the credibility of the allegations, but they will make sure that this is actually a child welfare complaint. It's not just a noise complaint or something like that. Assuming they do accept the case, they then farm it out to whatever the local jurisdiction is. So, for instance, ACS does not get the child welfare case directly from the source of the report. They get it from the state once the state decides that ACS should be the one who gets it. Like I said, the source can be anyone. There are a number of jobs or other responsibilities that are legally required to call in cases if they have a reason to suspect there is child abuse or neglect occurring. These are what are called mandated reporters. Police officers, doctors, teachers, social workers, things like that. These are all people who are legally obligated to call the case in, but anyone, like I said, anyone can do it, and the person who is calling the case in can do it fully anonymously. If you're being investigated for a child welfare, if you're the subject of a child welfare investigation, you generally won't know who the source is. You may have your suspicions, and there are certain situations once the case gets to court where you might be able to find out down the road, but while the investigation is happening, you will not be told who it is. And it's something to discuss with your lawyer down the road if it gets to that point, if it is going to come out who the source is. Now, just because an investigation gets started does not mean that the agency believes that the allegation is valid or that they suspect you're guilty. They're required by law to investigate every report that they get from the state central register. So once ACS gets the case, they're going to start an investigation no matter what. And these investigations can cover you whether or not you are a biological parent or if you have any parental rights. We'll talk a little bit more about this later, but the general rule is if you're a person legally responsible for the child, then you can still be found to have neglected the child, even if they're not your blood children. So what does the investigation involve? On the next slide, it's fairly comprehensive. They're gonna, at the very least, they're going to interview, the caseworkers are gonna come out, they're gonna interview the parents, they're gonna interview the child, they're gonna do home visits. The parents won't be involved in it, but they'll also speak with third parties. They might talk to neighbors, they might talk to doctors or teachers. If the case came from the police, for instance, they're obviously gonna talk to the police officer who called it in. All that kind of thing. It does depend on the situation sometimes, obviously. If the case involves a hospital, they're going to have more involved conversations with medical personnel and things like that. There's no obligation during the investigation for the parents to really participate in any of this. The parents don't have to talk to the agency. The parents don't have to let the children speak with the agency. The parents don't have to let the agency into the home because the agency is going to want to come in and do a home visit. With that said, it's often not worth, I'm sorry, I'm going to decline this other call. It's often not worth fighting with them about. It depends on your situation, and if you're uncertain, you're fully entitled to say no when the agency says they want to come into your home and speak to your children. However, as I said, I did these kinds of cases for many years. The first thing that's going to happen when you say no is ACS is going to court the next day and get an order that says it. And then once they have that court order, then they are allowed to, then you do have to let them speak with the children. You do have to let them into your home. If you fail to comply with that order, they can take more serious steps to try to enforce it. They can, we call it a knockdown order, where they ask the police to break down the door and let them into the home. They can have a parent arrested for failing to produce the child for an interview. The interview can happen at the home or it can happen at a separate location. One thing that often happens in more serious cases of alleged child abuse or neglect is there'll be what's called a forensic interview or a multidisciplinary interview. This is something that happens at a separate location. It's one interview done by a trained interviewer that is observed by doctors, police officers, district attorneys, agency caseworkers. The purpose of it is so that the child doesn't have to be independently interviewed by all of these separate um, by all these separate types of providers, but it will occur at a separate location, and the court can order that the child be produced to those to that location. And importantly, this does not necessarily happen in the context of an actual child neglect case. This is a separate filing. It's just asking for the order. Functionally, it works kind of like a warrant in a criminal case where it's requested from the judge before the case is actually filed. Now, what are they going to be looking for? When ACS or DSS gets a case, they have specific allegations. They get the call, and the report that they get says that their allegation is that a child is being physically abused, or that drugs are being used, or that the home is not safe for a child. With that said, they're going to look into everything. They are going to do a home visit, and even if there's no allegations that the home is unsuitable, they're still going to check to make sure things are clean. They're going to look in the fridge. They're going to want to make sure there's food for the child. They're going to ask general questions about how the children are disciplined. Oftentimes, they will ask to do a body check of the child, where they ask, if the kid has long pants on, they'll ask them to roll up their legs, pull their shirt up so they can see their stomach, that kind of thing, looking for marks and bruises. These aren't always requested, and especially in what we would consider more serious allegations of abuse or neglect, then obviously the investigation will be a little bit more comprehensive. But ACS or the DSS will really be looking into everything in your life while the investigation is going on. They'll also ask about your history. When the caseworkers are looking you up in their system, they can see your entire background in terms of prior child welfare cases. They'll ask about criminal histories. If they're speaking with the police, they'll ask about if there's been any prior police involvement. They'll ask about mental health treatment. They really do ask kind of about everything, oftentimes more than is necessarily required. As you can imagine, each allegation is separate and specific. If a child is alleged to have been educationally neglected, meaning the child's not going to school consistently, ACS is still going to check and see if the child's being disciplined improperly and make sure the child has food, things like that. There will also be conferences. These will start during the investigation itself, but they will continue pretty much through the lifetime of your involvement with DSS or ACS. One specific one that happens in New York City is called a Child Safety Conference. This is a conference between parents, caseworkers. There's a kind of like a mediator who's an ACS employee, but is someone who's intended to be neutral to help the conversation flow. And these conferences are very important because, especially at that CSC, the Child Safety Conference, that's where the determination can be made if ACS is going to remove the child. When I say remove, I mean take the child out of the home and put them into foster care. So it's very important to participate in these conferences and to be prepared for them. Don't show up late as much as you can avoid it, and definitely don't miss them if you can avoid it. Also, during the investigation, there'll be discussion of services. And Taylor, we can go to the next slide. When I say services, it's kind of a catch-all term that'll be applied both during the investigation and the court case itself. And these are just the steps that ACS or DSS wants the parents to do in order to address the concerns that the department has. So there'll almost always be some kind of parenting skills program, because from the department's perspective, if there's a child welfare concern, then there's probably some kind of parenting skills that need to be addressed. Otherwise, it's case specific. If there are allegations of drug use, they're probably going to ask for drug testing and drug treatment. If they're going to ask if the case involves allegations of mental health concerns, they're going to ask for a mental health evaluation and testing. If there's an allegation of violence, they might ask for anger management or batter's accountability. It's important to note that these are never mandatory unless they're in a court order. And again, I'll talk about them later. However, it can be beneficial to participate in them, because just because ACS has a case against you doesn't mean they're going to go to court and try to have a finding that you're neglectful. And oftentimes by engaging in the services, if you can kind of show to the department that you're taking their concerns seriously and you complete the program, or for instance, if you take a bunch of drug tests and they're all negative, that can really go a long way in terms of helping the aid to avoid there being a court filing. Again, it's very situation and case specific, so if you're not sure, it's something that you can decide for yourself and discuss with your attorney. But it's something that it's worth considering. In terms of the services, who they're sending to the services and where they're sending you, the agency or the department is always supposed to give you a referral. It should be in writing, often it won't be, but there should be a specific location. You should have a name. Ideally, they can help you with the appointment or at least give you contact information for you to make the appointment. And if the agency sends you somewhere, that'll be somewhere that the agency is going to accept as a valid service provider. You don't have to use their service providers. You can find your own service if there's someone that you like more, someone that's more geographically convenient for you, things like that. But you should always check with the caseworker if the service provider is accepted, because they have to be certified. They have to have the appropriate credentials. They have to be able to tell the agency that you're attending. One way this comes up a lot is people who are alleged to have alcohol problems. Often they try to go to AA, Alcoholics Anonymous. By definition, they can't tell ACS if you're participating because it's anonymous. ACS is always going to support you doing AA, but that's not going to replace alcohol treatment because there's no way for anyone to independently verify that you're participating other than you. It says on the slide, the services are very kind of family inclusive. So some of them will be individually just for the person who's alleged to have caused the problems. Oftentimes, there will also be recommendations for the children to engage with some kind of mental health counseling, especially in more severe cases of alleged abuse or neglect. Often, the people who are not alleged to have done the abuse or neglect but are still connected with the family will also be recommended for services. This especially happens in situations of domestic violence, where the department will, of course, recommend that the perpetrator of the violence engage in services, but they'll also recommend that the person who was the survivor of the violence also have their own separate counseling to help them kind of process that trauma. Again, it's never mandatory during the investigation stage, but these same services will be discussed when the case goes to court. And as I said, if there's an order for it, then it becomes much more important to comply. Moving on from that, eventually the investigation will conclude. This is supposed to happen within 60 days of the investigation commencing. It doesn't always, especially if there's an initial investigation that gets called in, but then there are more allegations that get called in later on, or there are a number of reasons why they can be extended, but the general idea is that they should end within 60 days of starting. When the investigation closes, the subjects of the investigation, the family, is supposed to get a letter that tells them what the outcome was. The letter doesn't always come. There's no good reason for it. People just don't always get it. It doesn't always get sent. It gets lost in the mail. Things happen. When you get this letter, assuming you do, it'll tell you if your investigation was substantiated or unfounded. And if you don't get the letter, you should ask the caseworkers about it. But when you get the letter, it will tell you what the outcome was. The best outcome for the parent is for the case to be unfounded or unsubstantiated. This essentially means that the department has investigated the allegations and does not have enough evidence to conclude that they happened. And when I say enough evidence, the standard just recently changed to a preponderance of the evidence, which basically means the majority. 51% of the evidence shows that this is the outcome. This was a fairly recent development. I think it was in 21 or 22 that the standard was just raised to that. So if you have an older investigation, there was a different standard, but since then it is now a preponderance. Turning back to the outcome, if your case is unsubstantiated, that means it's done. ACS should be closing out the case. There'll often kind of be there might be one final meeting where they, tell you what the outcome was and, kind of a final wrap up to put the final pin in it. But At that point, the allegations are closed. When a case gets unsubstantiated, it is sealed. It's ostensibly fully confidential. It's never allowed to be considered against the parent in terms of future investigations, future court proceedings, that kind of thing. Any parent who gets a letter that says their case is unfounded should definitely keep that letter, because I have seen that despite the fact that it's sealed, there will be times when these cases are considered by the agency or the department. I've actually seen reports prepared by caseworkers intended to be submitted to the court that talked about unfounded cases. So it's very important to have the documentation that your case was closed. On the other hand, ACS or the department might decide that there is enough evidence to support the allegations. This is called substantiating them. Essentially, when this happens, it doesn't necessarily mean that the case is going to go to court, but it does mean that the department believes that you, or the subject of the allegations, perpetrated them. When this happens, it automatically is saved into your record, depending on what type of the allegations they are. That they can be from 8 years if it's a neglect case, up to 10 years past the youngest child turns 18 in an abuse case. This is never public, but this record is available to anyone who essentially has a good reason to ask for it. So if a parent ever applies to work at a daycare or in really any kind of child-facing work field, at a school or something like that, they'll send a request to the SCR to check if they have child protective history. If a parent ever wants to become a foster parent or adopt a child, it'll come up. So even if you don't go to court, having a substantiated abuse or neglect case, or having a substantiated SCR report, can have very serious consequences. If the case does go to court, then that will significantly affect kind of the outcome of that substantiated case once the court case resolves. But for the immediate steps, it's functionally the same whether or not the case goes to court. It still gets saved into your record for the time being. However, on the next slide, we talk about how you can appeal the outcome. Obviously, if the case is unfounded, there's no reason for you to appeal. That means they're closing it out and there's nothing further for you to do. If they do substantiate the case, then the parent does have steps they can take. Generally, this is kind of a 3-level process, and there are very specific time limits on each level of this. So if a parent gets a substantiated case and wants to appeal it, it's definitely time for them to start talking to a lawyer. The first step of the appeal is to request an administrative review. This is not something the parent really participates in. There should be instructions on how to request this in that letter that the parent's supposed to get. But essentially, once the parent requests this, that's all they do. They request it, it goes to the state level, the state requests the records from the county or city agency that conducted the investigation. That all gets sent up to the state, and the state 9 times out of 10 agrees. Almost always, the outcome of this administrative review will be that the investigation is upheld unless there was something that really went wrong during it, or there was some gross misbehavior by the department. So once the parent gets the information that the administrative review has failed, or if it's just taking too long, the next step or alternate step that's available is called a fair hearing. This is, again, something that's requested, but in this process, the parent gets to participate, and this is conducted before an administrative law judge. It won't be held in an actual courtroom most of the time. Often it'll either happen at a local department's office, or especially in this day and age, it will happen virtually. Despite it being virtual, it's a full, real hearing. It feels more informal than an actual court proceeding. It'll be more conversational. The rules of evidence are a little bit looser, but it's still real court. They're still going to be making a decision at the end of it about whether or not that report is substantiated, and that will be at the conclusion of a hearing with evidence, testimony, documents, all that sort of thing. The last step that's available if the fair hearing doesn't go the parent's way, is to file what's called an Article 78 petition. And essentially, this is an administrative petition. It's a request for a judge to essentially review the actions of the fair hearing and to say that the fair hearing judge was wrong. This is very much real court. It's going to require a formal filed petition. We call them an Article 78 petition, where it's alleged that there's specific, overreaches from the judge, or that the fair hearing was conducted improperly. It's kind of the last step that's available to parents. Once that's done, it's just in the court system, and all they can do is go up the appellate chain. But it is the most serious kind of first step that can be taken. Now, once the case has been substantiated, notwithstanding any appeals, the next question is what's going to happen immediately. And on the next slide, I'll talk about removal. When we say removal, what we're generally referring to is children being removed from the care of a parent. How this usually happens is either the children get taken out of their home and placed somewhere else, or the parent gets kicked out of the home by an order of protection or something like that. Very important to know, the department or the agency does not need a court order to remove the children. If the agency comes to the house and wants to talk to the children, the parent doesn't have to let them. If the agency comes to the house and says, we're removing the children, these children are not in your care anymore, the parents do not have the legal right to stop them. And if they try to, the police will come and people will get arrested. Obviously, this is a reserved for more severe or more emergent situations. The standard is really imminent risk to the child, and I'll talk more about that later. In the event that there is a removal without a court order, the department's supposed to go to court the next day to kind of get the court to weigh in. But if ACS shows up at the door at 4 a.m. and says, we're taking these children, the parents need to comply, because if they don't, the police will get involved and the parents will end up going to jail. Once the children get removed, what rights do the parents have? The one thing that people don't know is that you don't necessarily get to know where the children are going to be placed. You can give information, and in fact, ACS and the department has an obligation to get information from the parent about resources, friends or family members that the parent would propose as an option to care for the children, both immediately, kind of while everyone's waiting for court, but also as a longer term basis. Your cousin can become a foster parent if they want to, and they have to get certified, they have to go through the whole process. But if you have a trusted friend or family member, that's generally going to be preferable to what we call stranger foster care, which is where the kids go with someone they've never met before. ACS does weigh in. They're going to do a background check on anyone that you propose. They're going to check if they have criminal history. They're going to check if they have prior child welfare history. And so it's not an automatic guarantee that if you have an option that they'll be able to take care of the kids, but ACS and the department is required to at least consider your resources as an option. With that said, if the children are going into a foster home and it's not someone that you know, like I said, it's called stranger foster care, you don't get to know where they are. Foster homes are confidential. When the case notes get circulated down the road, the agency will redact the specific information of the foster parents, address, phone number, that kind of thing. So you don't get to know exactly where the children are going. The agency has an obligation to ensure that the children are in a safe home, that the foster parents are fully credentialed and certified, that there aren't any safety issues, but it's not something the parents are generally told the actual name and address of the foster home where the kids are going. The agency also tries to keep children together, siblings, especially biological siblings, but also step siblings, half siblings, whatever it happens to be. It's in the statute that the department is supposed to make efforts to try to keep siblings together. They're also supposed to be in a culturally appropriate home. So if the children only speak Spanish, the agency has to try to find a home that speaks Spanish. It doesn't work all the time. There are many, many situations where the children will be placed in homes that aren't perfect. There aren't foster homes that speak every language available. If a family has 7 children, it's really hard to place them all together. If some of the children have specific unique needs, they might need to go to a more specialized home or even to a group facility. So there are never any guarantees. The agency should generally tell the parent if the children are being placed together, even if the parent doesn't get to know where they're actually being placed. But it's never a guarantee that the siblings will be placed together. In terms of visits, there's always an obligation. The parents are, any biological parent is entitled to have visits with their children. The specific frequency of these visits depends on everyone's schedules, the age of the children, any existing court orders, how many children there are, and so on. But if the children have been removed from the parents, then there is supposed to be a visitation schedule put in place. And it's really important that the parents stick to that, because they want to see their children and continue that bonding time, but also because participation in visits is something that's considered in future decisions, both from the agency and from the court. In addition to parent visits, if siblings are split up, there are supposed to be arrangements made for sibling visits. So everyone gets together and goes to a park or, goes out to a restaurant, something like that. We'll all go get McDonald's. The parents won't necessarily be at that. It'll often be arranged with the caseworkers or the foster parents. But it is supposed to happen whenever children who are either related or came from the same home and have a significant connection to each other are being separated. Now, like I said, in the event of a removal, you're supposed to go to court the next day. It doesn't always happen, but that's a good transition into talking about the court proceedings. So before we talk specifically about court, a couple of questions that people often have. How can you be charged with neglecting children that aren't yours? Because the law says you can. The law doesn't say that you have to be a biological parent or even have legal custody of children to neglect them. The standard, I mentioned this earlier, is that you're a person legally responsible. And what that actually means, it's someone who has a significant connection to the children, who performs a parental role for the children, at least in some regard. And it's very case-by-case specific. Generally, a babysitter who comes over once a month probably isn't a person legally responsible. On the other hand, if you're dating someone who has a kid and you watch that kid regularly, take the kid to school, take them to doctor's appointments, discipline the kid, feed the kid, then you're probably a person legally responsible. So it does depend on the situation, and in the event that the charges get brought, it is incumbent upon the department to prove that the person is either a parent or a person legally responsible. But just because you are not actually the biological parent of a child does not mean that you are safe from being charged. Now, even if you're not being charged, you should still go to court if you have a significant connection to the family. Generally, family court proceedings are open. Anyone, whether they're connected to the family or not, is theoretically allowed to sit in the courtroom. The court might ask why you're there if they don't know what you're doing there, what your connection is to the family. And the court can close the courtroom if they need to, but as a general rule, family court proceedings are open to the public. And specifically, if you're a parent or a close relative of the children, if you have a really close relationship with them, it's definitely worthwhile to participate in the proceedings. Usually, a non-respondent parent will be assigned their own attorney, and that person will be there to help guide that person through the court process. Obviously, you're not being charged if you're not a respondent, but the court will still be making decisions that will affect you. It'll affect what the children are doing. It'll affect how frequently the agency is coming to your home. It'll affect the respondents and their relationships to the children. That's obviously something that's significant to everyone. So even if you're not actually named as the person who perpetrated the alleged neglect, you should still participate. Now, on the next slide, I'll talk a little bit about what happens when you go to court. The way these proceedings begin, setting aside that thing I talked about earlier where the agency gets a warrant, When the case actually begins, it's because ACS or the DSS filed a petition 99 times out of 100. This doesn't happen every time a case gets substantiated, but it will happen in every case where there was a removal. It's a legal requirement. Usually the first appearance will be in person. Depending on the specific court and the specific judge, down the road, some of the types of hearings or conferences might occur virtually. In New York, these are generally done via Microsoft Teams, but it is very case by case specific and judge by judge specific. I mentioned this earlier, but I'm going to say it again here. Even though these are virtual proceedings, they're real court. There have been dozens of viral videos of people who don't take virtual court seriously and suffer the consequences. There was one this week that some people might have seen where a guy showed up to his criminal case for driving without a license, and he was driving when he signed into court, and the judge sent him to jail immediately. So these can still have very serious consequences for you. You should treat them as formally as you would real court. You should dress like you're going to court. You shouldn't do it somewhere loud, or you should where you can't hear the court. You should make sure that you have a stable device and a stable connection. Don't sign in with your phone at 3% battery. Don't sign in with only 1 bar of service. You can download Microsoft Teams before the court appearance happens and do a test run. And I would always recommend that you make sure your Teams is working. Make sure you have your real name, not a name that your cousin put on there for you, because it's taken just as seriously as a regular court proceeding. Now, like I said, the case is started by the agency filing a petition. When the case actually goes to court, no one knows right away. If in the event of a removal, it generally happens the same day. But if the case is just filing what's called a supervision case, or if the agency is filing what's called a supervision case, where they're not asking for a removal, but they are asking for ongoing oversight and services, that can take days or weeks before it actually goes to court. Again, very dependent on your jurisdiction. In the event of a removal, you should be ready to go to court at the drop of a hat. I have had cases where we filed a petition and I didn't hear anything for a couple hours. Then I got an email that the case was being called in 10 minutes. So of course I dropped everything and went down to court. Usually the agency will know when the petition is being filed, and they should be able to tell you when the case is going to be filed with the court. But when the case is actually going to be heard is a very different story, and that's something that can happen on very short notice. Any parent who is charged with neglect has the right to have an attorney. If you have the financial resources, you can retain one of your own, or there are what's essentially functionally like a public defender. Every location has its own name for it. But an attorney can be assigned to a parent who can't afford it. Often at the first proceedings, the court will have a little inquiry with the parent about their financial situation, what their income is like, where it comes from, what their obligations are, how many children or family members they're supporting. But the court will make a determination about if a person is entitled to have an attorney assigned to them. Very, very important, parents, to stay in touch with your attorney. It is very problematic if a parent loses their attorney's phone number and the attorney doesn't have, and the parent changes their phone number. If the attorney can't get in touch with the parent, the court dates can change. They won't be able to tell the attorney won't be able to tell the court why the parent isn't present, and the court can basically do everything it can with the parent, even if the parent's not there. So it's not going to prevent the proceedings from moving forward. It just prevents the parents from participating and getting to tell their side of the story. Some people want to represent themselves. You shouldn't do that. That's just all I can say. It's almost always a bad idea. Lawyers don't represent themselves. If I was charged with abuse or neglect, I would get an attorney. I would not represent myself, and this is what I do. It's something that you're allowed to do, and if you tell the judge that you want to represent yourself, the judge will ask you a whole bunch of questions to make sure you're really sure you want to represent yourself. If it's usually not a good idea. There are very specific rules of evidence, rules of decorum. It's harder to kind of have the conversations with the attorneys and the caseworkers when you're representing yourself. It makes everything much more complicated. And usually your attorney will know a lot more about the process, a lot more about the people you're working with, and a lot more about what you should be doing than you do yourself. I know there's always a temptation to go online and read on Google how things should go, but every case and every court and every judge is different, and it is very rarely, I'm going to go as far as to say almost never a good idea for someone to represent themselves. Now, on the next slide, we talk about the initial hearing. This is the one that happens, if it's a removal, it'll generally happen the same day the petition was filed. If there's no removal and the agency is just asking for court oversight, it can happen down the road. But in any event, at this first appearance, the agency is going to be there, and usually the attorney for the child, the AFC, will be assigned. If the parent knows about it and has time to get there, they participate as well. Their attorney can be assigned and be present as well. But the first thing that's going to happen 9 times out of 10 is the court's going to ask, the court's going to ask the department what they're looking for. They're going to make applications. This is essentially the agency asking the court to issue specific orders. Like I've said a few times before, what they're going to specifically ask for depends on the situation. They might ask for orders of protection. They might ask for the court to confirm a removal and officially place the children in foster care indefinitely. They might ask for the children to be released to a parent, but for that parent to have to comply with certain obligations like services or drug testing. There will also be a discussion of visits if the children have been removed or if a parent's been excluded, and how those will occur. Do those have to be supervised, or can they be unsupervised? Can they be overnight? These are all conversations that ideally ACS or the department will have determined before going into court, and preferably they give everyone a heads up about what they're going to be asking for, but it doesn't always happen that way. The parent can consent, they don't have to. Depending on what the application is, there may be an actual hearing on some of the applications, and we'll talk about removal hearings in a little bit later. But the rule is always going to be to talk to your attorney about if you should consent to it. But even if you don't consent, the judge will decide if the services are necessary and issue an order. If that order gets issued, even if you don't agree, you have to follow it. Failing to follow the court's order is contempt. It will be held against you in future court proceedings. In theory, you can be fined or jailed for it. It doesn't happen often, except for in particularly egregious cases. But once the court issues an order that says that a parent has to comply with services, we're no longer in the voluntary stage of service compliance. I know earlier during the investigation I said you don't have to. Now you really do. You're really legally obligated to comply with the order, even if you don't want to do the services. Also important to know that the court can issue orders even against parents who aren't present. And again, depending on the situation, they may or may not be willing to issue those orders. But if the court issues an order and the parent isn't present, once the parent gets a copy of that order and is aware of it, they're bound by it. The agency will have an obligation to get that order to the parent, usually by serving them. And we talk about service on the next slide, but even if the parent isn't present, the order can still be binding. If the parent isn't present, next slide, Taylor, the case goes to return of processor, a return of service date. This is usually very straightforward. It'll often encompass part of the conversation about services and visits from the last date, from the initial hearing, I should say. But this is the part where ACS has had the obligation to find and get a copy of the petition and any existing orders to the parent. If they can't find them, there are other options they can ask the court to authorize. And ultimately, if the agency really can't find the parents, they'll go forward without them. There's a provision in the Family Court Act that allows for the agency to show to the court that there's no practicable way to serve the parents, and if the agency makes that application, the court grants it, the court will just go forward and do the trial without you. The next slide, I talk about what we call removal hearings. These are these can also be called either a 1027 or a 1028, because those are the Family Court Act statutes that really kind of set them down and set the requirements of them. Parents are entitled to one hearing generally to ask for their children to be returned. To get that first hearing, they don't have to show anything. They just have to go to court, say they don't agree with the removal and they want to do a hearing. When this happens, the hearing is supposed to commence within 3 days and then hopefully conclude quickly, not necessarily, but it's supposed to move as quickly as possible. These are considered very high priority hearings. And during that hearing, witnesses will testify, evidence will be presented, the judge will render decision at the end of it, as well as issuing interim orders kind of during the hearing itself to monitor the family as it's going. Like I said, they try to move them quickly, but they can take a long time. I personally saw some removal hearings that took months. So it's definitely worth considering. And like I said, you only are entitled to one hearing as the parent. So it's definitely a conversation that should be had with your attorney, because if we call it your one bite at the apple. Once you get it, if you lose your hearing, then you have to prove to the judge that you're entitled to a new one down the road. There are ways you can do that. You can show good cause for getting a new hearing, but you are only legally automatically entitled to one 1028 hearing. Once you're past the removal hearings and the initial appearances in the service, then we get into the conference stage on the next slide. There are a bunch of different types of this: PC, SC, CC, PTC. I listed them all earlier. They're all kind of similar, and there'll always be one preliminary conference, and that'll always be followed by some indeterminate number of the other types of conferences. To the extent that there's a type of family court appearance that's less important, it's these ones. They're not necessarily with the judge. Oftentimes the actual parties will be excused from these conferences and it'll just be held with the attorneys. And these are kind of just checking in on the status of the case. ACS or the department will give a report on how things are going. There'll be conversations about discovery, what evidence everyone's looking for, what evidence everyone's waiting on. If there's agreement to modify some of the orders, for instance, if the visit started out supervised and everyone says they can now be unsupervised, that can happen at these conferences. But these are kind of just a catch-all reviews that happen periodically throughout the case as things are moving forward. One other thing that's discussed at these conferences, on the next slide, we talk about settlements at the conferences as well. And these are basically all the ways that the case can resolve without going to trial. These can result in the finding being entered or not, depending on the situation. There's an ACD, adjournment in contemplation of dismissal, which basically puts the case on pause. There'll be an order issued and the parent has to comply with a bunch of terms in that order. And if they do that, the case goes away automatically. Nothing else has to happen. It's an automatic dismissal. It can be for up to a year. Usually I'd say 6 to 9 months is probably standard, again, depending on your situation. But this is the one that avoids a finding of neglect being made. There's also what's called a suspended judgment, and this can be paired alongside what we call a 1051A as well. 1051A is similar to a guilty plea or a no contest plea. And which of those it is depends on the situation. You can admit the allegations, or you can agree to sit there while the judge decides that they're going to make the finding against you. Either way, the outcome is functionally the same. You go past the trial, the court enters an immediate finding of neglect and moves to the next stage after that. One of the things that can come along with this is the suspended judgment. In that scenario, like I said, the finding is made, but there's a kind of a clause in there that says that in 6 months, in 9 months, the judgment will be suspended for that period. And if the parent complies with the orders, services, drug testing, mental health treatment, whatever it happens to be, if they comply with that, then the judgment can be vacated. Oftentimes the attorney will have to make a motion for the judgment to be vacated. It's often not an automatic vacature, but it is something that's an option. The rarest of these is when ACS or the department withdraws the case. That's basically them saying we don't need to be here anymore, either because everything's good now or we realize we were wrong. and that's when they ask to withdraw the case. The petition gets immediately dismissed, all the orders go away, and that's the end of it. If the case doesn't settle, then you have the trial. And on the next slide, I talk about what's called the fact finding. This is just the family court word for trial, often abbreviated as FF. This is where the judge sits there and hears all of the evidence, and everyone gets a full opportunity to present documents, to have witnesses testify, and to present their case. Importantly, this is pretty much the only hearing in a child welfare matter that does not allow hearsay. And again, this is a topic for you to discuss with your lawyer, but fact-finding hearsay is not permissible and admissible. Everywhere else it is. So it has its own specific rules of evidence and its own specific procedures. They're supposed to happen quickly. Some jurisdictions, they'll block it out for a full day and they'll go back to back until it finishes. Other places, you'll get 30 minutes every 2 weeks or 30 minutes every 2 months. These fact findings can take a very long time, but that's not necessarily a bad thing because this is where the judge decides, did the person commit abuse or neglect? I mentioned this earlier about staying in touch with your attorney, but I'm going to say it again right now. Very important to stay in touch with your attorney because the judge will absolutely make a finding of abuse or neglect whether or not the parents are there. So if it depends on the situation. If a parent's been there to every other court appearance, doesn't show up, unexpectedly one day and then text their attorney halfway through the appearance that their car broke down or they got in an accident, then the judge is going to be understanding. If the parent hasn't showed up to court in 6 months and no one has heard anything, the judge is going to do the trial, and that trial will be held, and the agency will win 99% of the time, and that trial will take less than 10 minutes. It's very, very easy to win a trial when there's no one opposing you. Whether or not the parent participates, assuming that the finding is made, then we proceed to the next phase of the case. Obviously, if the judge decides that there isn't sufficient evidence, then they'll dismiss the case, and that ends it. But assuming that the agency wins and the finding of neglect or abuse gets made, then we move to the phase that's after the trial. And we can go forward a couple slides, Taylor. So after the trial, how long are you going to be sticking around? Well, it depends on the situation. A case where children have been removed can theoretically last for years. The way if a child is in foster care or doesn't have what's considered to be a permanent placement, then the case stays open until that child has something permanent or becomes an adult. Depends on the situation. Generally, the child can kind of be permanently discharged from foster care when they're 18. They can choose to stay in it until they're 21. And certain jurisdictions, I know in New York City specifically, a request can be made, to keep the child in foster care for even longer. A lot of the time this will happen, for instance, if there's a foster child who is in college and if they were discharged from foster care, they won't be able to stay in college because they couldn't pay for it or something like that. If the child isn't in foster care, then there is going to be a concrete end time for the case. It'll be decided at what's called the dispositional hearing, which I'll talk about in a moment. But generally, the maximum default or the maximum initial length of non-removal post-fact-finding, post-dispositional case is 1 year. And that can be changed down the road, but that's where it's going to start at. So on the next slide, I talk about the disposition hearing. This is what's kind of like the sentencing hearing in a criminal case. The court has already decided whether or not the allegations were proven. This is where the court decides what's going to happen next. Some judges will do it basically at the same time as the fact finding, immediately afterwards. Other judges will do a completely different hearing. How useful it is to contest a disposition really depends on your situation and what's being asked of you, because the agency is going to ask for certain things, and based on the allegations, you can pretty much tell what the court's going to ask. If the agency has alleged that there's ongoing drug use, the court's going to order drug testing. And it's really not helpful to contest that because the court has already decided there's a drug problem. The court is going to find that drug testing is necessary. If the court finds that there is a pattern of violence in the home, the court's probably going to order some kind of anger management or batterers accountability program. So how useful it is to delay the proceedings and to honestly to upset the judge is something that's worth talking to your attorney about. But the court can tailor the dispositional hearing to the specific issues. So if you agree to most of the services, but there's one piece that you don't agree with, then you can tell the court that, and the court can just hold a dispositional hearing about the necessity of that one component of the dispositional order. Once the hearing is done, the court will issue that order, and it will contain, again, binding requirements of the parent for the parents to comply with things, usually including services. It'll have the children being placed somewhere that can be, released back to their parents, or it can be placed in foster care. In the event that the children are released to the parents, like I said, up to a year is the time frame that we can be talking about. The agency has ways to extend that. They can file to extend it for up to an additional year. They can also file a violation and ask for essentially a new order, which more or less restarts the clock. But by default, the maximum period of supervision for a non-removal dispositional order is 1 year. The dispositional order for children who are in foster care will say that it expires at the permanency hearing. It's not going to expire at the permanency hearing. That's just the order runs from day to day. And so it's going to always run until the next court date. And so when, if your permanency hearing is in 3 months, it's going to say the children are placed until 3 months from now at that permanency hearing. But that permanency hearing will be what extends that order and keeps the case open. And so I included the permanency hearings here as something that's post-disposition and post-fact-finding. Practically speaking, they're not necessarily afterwards. They're supposed to happen 8 months after the initial removal and every 6 months after that. The schedules get a little bit wonky depending on the court schedule, but in theory, these can happen before fact-finding. However, after fact-finding for children who are in care, these are kind of the ongoing formal court proceedings where the court continues the placement, modifies the orders as needed. There are wildly varying procedures for permanency hearings. These can include, these can be a full hearing with evidence and testimony, or they can be 5 minutes of the attorneys talking and then the court just makes a decision. Judges all like to do them differently. And so again, this is an area where having an attorney who's familiar with the procedure and familiar with the local authorities is helpful, because the way these are done can happen in very, very different ways. The outcome of these, there will always be a goal, and I've got the goals listed there, but the specifics of it aren't that important, except for that one of them is return to parent. That's the goal where the agency is supposed to be working on getting the children back home. All of the other goals that I have listed are ways for the children to end up somewhere that's not with the parent, whether it's with a new legal guardian, being adopted by someone else, turning 18 and being discharged to live as functional adults. Return to parent is obviously the one that the parents usually want, but the court can and will change the goal and change what the agency is expected to work towards at these permanency hearings. The permanency hearings, like I said, vary wildly. Sometimes nothing will change and they'll just kind of continue the status quo. The permanency hearing can also send the children home and immediately end the case. If the children get a final discharge from foster care, the case can be closed immediately. And so it's really important to kind of be aware of everything that can happen at these. I'll just briefly talk about what's called a termination of parental rights on the next slide. This is technically a completely separate proceeding from a child welfare case. It's a new petition, completely different, and it has the end result of cutting off a parent's legal parental rights forever. The reason why I mention it here is because they're closely connected to foster care cases. It's in the law that any child who has been in foster care for 15 of the last 22 months, the agency is supposed to be filing for a TPR, for a termination, unless there's a good reason not to. And so it's very important that everyone keeps that timeline in mind, because you really don't want your children to be in foster care for long enough to trigger that provision. Lastly, I just mentioned a couple of special considerations in foster care cases. If the child is either a member of a native tribe or is eligible to be a member of a tribe, even if they're not an actual member, there's a whole bunch of special protections. It's called the Indian Child Welfare Act. It's a federal law, so it's not just a New York thing, but there are a host of special requirements, and I could do an entire separate presentation just on ICWA. The court might not even be able to hear the case because it might go to a tribal court. There are special protections. The tribe gets to participate. Basically, if you think the child might be a member of a native tribe or could be eligible for membership, talk to the attorney. The last one that I want to mention is immigration. Generally, the court tries not to have anything talked about relating to immigration on the record. Oftentimes, if something needs to be discussed, they'll actually go off the record so that it doesn't appear in the transcript. Notwithstanding that, these findings can have very serious consequences. I have seen people get deported following from findings of abuse or neglect. So even if you don't want it discussed in court, any parent who has immigration concerns should have a conversation with their attorney about their concerns well before any real decisions are made. And that's the end of it. That hopefully gives everyone a bit of an overview of what these cases look like. I left a slide for questions. We're pretty short on time, but Taylor, I don't know if we got any questions, if you want to jump in here.
Yeah, if anybody has any questions, please submit them via the chat so I can send them over to Colin.
All right, I'm seeing one. Thank you for sending that over. Okay. So the question is, what happens at the end of the investigation? Do all parties get notified, and who would a party contact if they don't understand the paperwork? So like I said, at the end of the investigation, in theory, there's a letter that's supposed to be sent to the parents that tells them the determination on their case. It should say whether it's indicated or unsubstantiated. Theoretically, it's supposed to be translated into the language that the parents speak. So if the parent doesn't speak English, then it should, if they speak Spanish, they should get a letter that explains it to them in Spanish. I'm not going to say it always happens, but it's supposed to. But generally, every party who was, this is getting into the specifics of the report, but certain people will be listed as subjects of the report, and that can be, that includes the parents, but it'll also include any kind of third parties who are alleged to have been involved in the abuse or neglect. And that will, the people who are subjects of the report will get notified of the outcome for their specific report. They will not necessarily get notified of the outcome for the other subjects because everyone has their own investigation and different determinations can be made. In terms of who the party would contact if they don't understand, the answer is going to be the attorney or the caseworker. If they've retained an attorney, then that's going to be the person they should be talking to for advice. If they don't understand the paperwork, really their only option is to talk to the supervisor or the caseworker. I will say that depending on your local jurisdiction, there may be free pre-court options available to you. I know, for instance, in New York City, most of the boroughs have an institutional kind of public defender entity. They all have different names, but they all exist outside of Staten Island. And oftentimes they will be able to give some kind of consult information, even if you don't have an active court case. The next question was, what's the role the children's law guardian plays in these cases? And for anyone who doesn't know, law guardian basically means the same thing as AFC in this context. It's the attorney who represents the child. Their job is to represent what the child wants, which is not necessarily what's in the child's best interests. So ACS is theoretically supposed to be representing what they believe is in the best interest of the child, and the court is supposed to make those decisions as well. But the kid might not want that. A 14-year-old might say that they want to go back home, even if it's not a safe place. And so it's the AFC's job to kind of parse what the child wants and to represent them. For very young children, or children who are otherwise unable to articulate their position because of mental limitations, something like that, the AFC can substitute judgment, where they will make their own decisions about what's best for the child. But in theory, the idea behind the AFC is that they represent what the child wants as opposed to what ACS thinks is right or what the parents want. Next question was, when can you prove that CPS did something illegal? You're going to want to talk to your attorney. A lot of the time, what people think CPS does is illegal isn't actually illegal. I'm not going to say everything they do is legal. There have been many, many lawsuits where ACS overstepped or, was discriminatory, or plenty of other issues have arisen. But you're always the avenue that's available, short of just complaining to the supervisors and calling in the news. The avenue that's going to be available is filing a lawsuit, and that's a very complicated process. You're suing the city and an agency, or the county and a department, and you're going to want to talk to a lawyer because there are lots of very specific obligations there. If you think they committed a crime, call the police. But like I said, they might be able to break down your door. They might have a court order that says they can. They might be able to take your children against your will. They sometimes have that authority. So it's definitely worth speaking with a lawyer before you take any steps, because anything that you do during this entire process is under a microscope. Next question was, who pays for the services referred by the court or DSS? Depends on the situation, and it's a conversation that everyone is supposed to have. Many of the providers work with Medicare or other insurance, so there are ways to get them covered. You also oftentimes, if a parent tells the department about their financial restrictions, then they can find services that are free or low cost. I can tell you, as a matter of policy, ACS theoretically is supposed to pay for any services the parents can't. That's not in the law, and so it's not going to be the case in every single department. But the court can order anyone to pay for the services. So if the parent can't pay for them, then the parent can ask the court to order the services be paid for by the department, by the DSS. But it is something, there is a specific, I know in New York City, there's a specific procedure for the agency to be the one who pays for the services. Again, in the scenario where the parents aren't financially able to. I saw a long question in the other chat about if one parent was unfounded and one party was indicated, who gets to know what happened. And then the question kind of goes on to ask a number of specific case-specific questions. And unfortunately, I'm not going to be able to give kind of that information because I can't give your specific legal advice on your case. But what I can say is that every subject of the report is considered to be their own investigation, and and each of the subjects is not entitled to know what the outcome of the other reports was. So if two parents get investigated and the agency decides that only one of them was the perpetrator, then only the person who perpetrated the abuse or neglect is supposed to be it will be indicated, and they'll get that notification. The other person should get unfounded, and they should get that notification. There's never a guarantee of that, though, and one way that this can often come up is in what are called failure to protect or knew or should have known cases. Basically, if one parent is doing something wrong and the other parent knew or should have known they were doing something wrong and didn't do anything about it, that's a basis for neglect, and so that can lead to a case being upheld and a court case being brought just based on that. I think the rest of the question was pretty case specific, and so I'm not necessarily able to answer that. But I hope this has been helpful to everyone, and I appreciate everyone for taking the time to listen to me today. Yeah, thank you very much. Anything else, Taylor?
No, I just want to thank everybody for joining today's presentation, and thank you for presenting. Today's webinar was recorded and a copy will be sent to all attendees early next week. I hope everyone has a good rest of their day. Thank you.
Thank you.